All right, good evening, everyone. I'm calling the February 13th, 2019 meeting of the Wilmington Zoning Board of Appeals to order. It's 7:03. I have some cases that are to be continued. The first matter is the actual, is case 718, 362 Main Street, Bettering LLC, map 89, parcel 6A. That was originally going to be held today for the actual signing of the decision. Town council is not present, he's on vacation, so that has been continued to the meeting of February 27th. Then we have case 1318, 220 Main Street, Noria Energy Retail Incorporated, map 44, parcel 178D, to acquire a special permit in accordance with 3.5.14, car wash for property located at 220 Main Street. The applicant has requested that that matter be continued to our meeting on March 31st. Oh, is that right? The 13th, March 13th. Do we have a motion to that effect?
So moved.
I'll make a motion to continue case 7-18, is that the right one?
Yep.
To the,
Oh, no, 1318.
13-18.
Yep.
To the March 13th meeting.
Do we have a second?
Second.
All those in favor? Aye, that matter is continued to the meeting to be held on March 13th. There is a second matter that's seeking to be continued, which is case 1718, 220 Main Street, Noria Energy Retail Incorporated, map 44, parcel 178D, to acquire a special permit in accordance with 6.6.6.12 for groundwater protection district for the property located at 220 Main Street. Looks to be a companion case to the first one. Do we have a motion to continue that?
Make a motion to continue case 7-18 to the March 13th meeting.
Do we have a second on that?
Second.
All those in favor? Aye, that's unanimous. That matter is continued. Then we have case 1918, 7 Concord Street, Lijun Zhu, care of F. Alex Para Esquire, map 62, parcel 29. The matter to appeal the decision of the building inspector dated September 14th and September 23rd, 2018. Airbnb strictly prohibited for the property located at 7 Concord Street. Do we have the applicant here? Come on up. How are you?
I'm good. How are you?
What's your name, sir?
My name is Alex Parra. I'm an attorney in Acton, and my client Julie Zhu is with me tonight. So we appreciate the opportunity to meet with you tonight. I had submitted a memorandum. I mailed it in back in the beginning of January, kind of laying out the legal issues. At the time, I had not been provided with the opinion of town council that apparently the building inspector was relying on.
Have you been provided with that?
Yeah, Jonathan Silverstein has now provided it to me. And I think that's a good starting point because, first of all, I'm pleased to say we both were looking at the same cases. So, we're not in different...
That's usually the case, but,
no,
but the opinions diverge.
No, but we're not in different universes, which can make things a little more difficult. So some basic facts. Properties at 7 Concord Street, and it consists of 2 houses kind of almost joined together. And back in 1986, this board granted a special permit for the property for an accessory apartment. And those provisions are still in the Wilmington zoning bylaw. In that special permit, and I don't know the background, I wasn't able to understand the background, but there was a Superior Court judgment that affirmed that special permit as permitting, wait a minute, just let me finish. affirmed that special permit. So what we have here is a Wilmington zoning bylaw that permits accessory apartments, that permits boarding in single-family residences as accessory uses, not accessory in the normal sense of subordinate to a principal use, but as expressly permitted uses in the Wilmington zoning bylaw. I think everybody here would agree, you know, Wilmington is governed by the Wilmington zoning bylaw, the two cases that both Jonathan and I, you know, referred to. Hull is Hull. Hull has its own zoning bylaw, doesn't have reference to Wilmington. Linfield, the same. This town legislates its zoning independently. So the cases have value for you only in looking at how the courts would look at this case if the appeal, you know, were to go further up the ladder. And Jonathan's letter to the town is not specific to this case. It's just generally addressing Airbnbs or short-term rentals. The interesting thing about these two cases is that the facts are very different. In the Hull case, the zoning bylaw makes no provision of any type or kind for accessory apartments. And so the court was looking at that set of facts and trying to see if there was something else in the Hull zoning bylaw that, you know, would permit this use, and made the determination that there wasn't. Okay. The Linfield case is a little bit different, because in the Linfield case, they actually had a provision in the zoning bylaw for what they called tourist homes by special permit. And in that case, the property owner had never obtained a special permit, just went out and started renting it through Airbnb. And Linfield then adopted a provision that expressly prohibited short-term rentals. And the owner raised his hand and said, well, I'm grandfathered because I've been doing this. And the court said, no, you're not grandfathered because what you were doing was illegal because you never got a special permit. So you're not grandfathered, and now you're prohibited. So I would ask, and I don't really expect that the board is prepared to, to grant our application tonight. I recognize.
Unless you wanted us to engage in extreme judicial activism.
Right. So I think what I would ask is that, and I've just provided a very short response to town council's letter, which I'll submit to the board, basically just says what I just told you. I would ask that you go back to town council in light of the specific facts of this case. That
Are you saying that he hasn't been appraised of those facts?
I don't know what he's been appraised of. The only conversations I've had with
Whatever the building inspector, whatever he came up with, his decision, I'm sure, was transmitted to council.
Well, but his decision is in a similar way not fact-specific. It just says it's prohibited in town.
If you, just hold on one second. If you, this is how I feel, only one person. If you want to elaborate additional facts that you don't believe council has, I have no problem continuing it to allow council to review that and see if his opinion has changed, because obviously his opinion is that this isn't warranted. So if you don't believe that he's either, viewed or considered some facts that you think weigh on how that opinion may be construed or if it may be changed, I have no problem with that. I mean, if you want to do that, but I would say that it's incumbent on you to put that together and get it to council.
We put it together in the form of the memorandum submitted.
This is the most recent
No,
submission?
no, the January 9th letter to the board with the attachments and exhibits.
Well, he's got that. Council had that when he made his opinion, correct?
No,
Oh, you're saying he didn't have
no,
that?
he did not have that. The opinion is dated back in December.
Gotcha, gotcha.
And my understanding from the building inspector, who, by the way, is a very nice gentleman, is that his opinion was based on, I mean, he was doing this because this was a prescription townwide as opposed to the basis.
So let me get this
of
straight.
a-
Are you asking that we continue the matter to provide counsel with your memorandum to see if it affects his opinion?
I think that, I would, yeah, I would
I mean,
think that was a.
it's your application, so.
No, I think that's the appropriate way to proceed. I mean, otherwise, you're faced with the position, even if you want to grant me the approval that I've asked, is you'd have to say, well, town council doesn't know anything, or the building inspector doesn't know anything, and obviously, I don't expect you to do that.
Yep, okay.
Okay, so a couple of things.
Yeah.
So our inspector has stated categorically that it is not permissible to have a short-term rental use and a commercial use. It's strictly prohibited.
Correct.
That's a fact, right?
That's what he said.
Okay,
yes.
so you have all the information. What are you saying? You saying that you disagree with him? Because if you come before the board, this is my opinion, you have all the facts, you've had the facts before, this has been continued, now you want to come back and give us more facts? I mean, you got to come up with something that determines how you're justifying this denial of the inspector. So what are you saying?
So there are two levels here. One is, and I can only go on what I've been told, okay, is that the building inspector's original decisions here were issued not based upon the particular facts of this case, but based upon an opinion rendered by former town council as to that use generally in the town. And then subsequently restated by current town council. So,
Or reevaluated
or
and agreed with.
okay, fine.
I mean, I
yeah,
guess
no,
I'm a little hesitant. I mean, you're picking apart council's opinion, even though you state that it's based upon the same case law. But you're kind of picking it apart, and he's not here to kind of, to tell you what he based it on and the facts that he was
agree.
here. So, I mean, you know, the other members may have a difference of opinion, but I mean, if you're looking to provide additional facts that he apparently didn't have, I don't have a problem with that, but.
So the only thing I have a problem with, if you have additional facts, that's fair, but you have to do that before you come here. So if you go to town council and you say, look, there's something additional you may want to look at, because it may want to change your view on that, that works behind the scenes. So then eventually, if you do prevail, then he will come back and say, based on what has been given to me, additional information, I'm changing my ruling. So I don't know why.
He provided that, Tom. It just hasn't gone.
But council gave his opinion before.
No, but I'm saying if he has additional.
He's already submitted it, and he's asking us to make sure that town council has seen it. And I don't believe town council has seen it yet.
So why would he ask the board? Why wouldn't you ask the town clerk that? I don't understand why you're coming. Now you're gonna come back again. So what are you asking of this board? I just don't understand.
Well, what I'm asking of the board ultimately is to overturn the building inspector's decision.
Right.
And the basis for asking that is that this property has been granted a special permit for an accessory apartment that's been in place since 1986 and affirmed by the Superior Court. And those facts we submitted previously before I was given town council's opinion. Now, I asked, at the time that we filed the application, I asked for a copy of town council's opinion so that I could understand what we were dealing with. and was told at the time, you can't have it, it's attorney-client privilege. That position has changed.
Well, you filed it with the clerk, right?
I filed the application.
No, the opinion was ultimately filed, correct? The town council's opinion.
What town council told me the last time we were here, when you had a very large group, was that he needed to get permission to give me the opinion. And apparently he did get permission, and I received it by email last Friday. So, and that confirmed to me what I'm saying to you tonight, is that opinion, there's not, in town council's opinion, there's not a single mention of 7 Concord Street or any other property per se. It's a discussion of 2 land court cases and what he thinks about them. There's no mention in his letter of the provisions of the Wilmington zoning bylaw that are different from, very different from, those of the town of Hull and Linfield, the cases that he cited. And again, I'm not asking you to be town council. I think it's reasonable if you're willing to put all that information to town council and see if he agrees that you can grant us the relief that we're asking for.
Well, I mean, what I would assume we would do is just provide him your memorandum and ask him if that changes, if that substantially changes his opinion. It's probably the easiest, quickest way to do it, right?
Yeah, and I'm happy to.
I'm not gonna have 2 attorneys going at, this isn't a court.
No. Again, I'm just trying to do this in a reasonable way.
I get it.
That's all.
I get it.
And may I add a couple things? One thing, from what I know, just recently, Massachusetts passed a law about to allow the Airbnb with some restriction, and there's a time limit, but that is Massachusetts passed the law, and the resident can host the guest through the Airbnb. This is what I know. That's the first thing. Second thing, I would like appointed in our neighbor town like Andover and in Cape Cod like Sandwich, they allowed to have Airbnb. So I host, guests and screening them very carefully. I never had a trouble. And my guest is, they are very honest. They are nice people. I enjoy to host them. So to me, Massachusetts allowed that. And some town in Massachusetts allowed that. Definitely there's some town, don't allow them to do that. But a lot of town allow.
Do we have a planning board recommendation on this?
No.
They didn't give one out? No. Okay. I'm gonna kick it back to the board in a minute, but I just wanna see if there's anybody here that wishes to be heard on this application. Going once, going twice. Public hearing is closed. I'll open it up to the board for whatever the pleasure of the board is.
So I do have so I didn't, other than the January 9th memo that came through, the original application and Jonathan's memo, I was surprised to find out after that there was actually an issued special permit that had been issued for an accessory apartment. I didn't realize that. I thought it was just a single-family house where somebody was renting out a bedroom or renting a part of the house. So that, to me, that changes my whole approach on this, because the section in the bylaws that are related to accessory apartments don't really stipulate short-term rental versus, so I actually think that the I'd like to hear Jonathan's or our town council's opinion related specifically to the special permit that's in place for this property as an accessory apartment, because there's an apartment there. So if they rent it, I mean, that's what they were given permission for an accessory apartment. So I'm confused as to why Jonathan's or the town council's opinion didn't factor that in. I mean, I think it's different if it's a house and they're renting out a bedroom and a bathroom. To me, that changes the whole thing.
I think the issue is that there's no clarification, there's nothing that says about short-term rentals. The issue is short-term, whether it's a week, a day, a month, that's where the problem comes, because my understanding is because it wasn't mentioned on a time frame, then it's prohibited. Since it's prohibited because there's no time frame. I don't think that when they had accessory apartments or they allowed that part, they didn't have short-term rentals at the time, or it wasn't as popular as it is. And that's where we need to define, there's no definitive language on the short term. Now, I'm just curious, one of the reasons I feel that this probably came up because neighbors were bothered. Because otherwise, it probably never would have.
I never got a complaint, never.
But somebody had to have, because that's why you're in front of us.
And from the building inspector, and he checked everyone in town for the short-term rental. And from what I know, he sent everybody a letter. There's case just like the gentleman mentioned, they rent a partial of there's a house. They are not the same as my case. He sent everybody a letter to stop the Airbnb rental. That's it from what I know.
But there would be no, like, the building inspector's not gonna say, okay, I need to see a lease, and how long are they there for?
He didn't ask. He said just nobody can do that in the town. That is I talked to him before. He said I send everybody a letter. So.
But everybody, so
But
unless.
everybody, the other people, their case is different from my case. And some of them just rent a partial of their house.
But there would be no way of him actually, like, how did he know? How do you?
I think
So-
we're speculating, but I could figure out that he might have just gone on Airbnb and looked at
If
Wilmington,
you see,
and you would get a list.
that's it, just the room rental, that will be partial. Just,
I can understand what you're saying, but I think he's so busy, he's probably not,
Yeah,
like,
he doesn't-
targeting,
yeah, that's
you know,
true. I think
Airbnb,
this-
unless there was a
Exactly.
problem, and there had to be.
I never had a problem. My neighbor
But you might
never
not have
complained.
known, but
Yeah.
maybe neighbors
Maybe
actually
the-
came and
Well, the simple way to
complained.
find out is to ask him.
Yeah, do you know what I mean? So anyways, the bottom line is that there's no quantified amount of short-term, and that's what we need to figure out.
What are you asking for? So I can have any member of the board who's so inclined to make that motion, make it.
Well, I would suggest simply that the matter be referred back to town council with.
So you're asking that the matter be continued and your memorandum be provided to town council to determine whether that affects his opinion?
Yes.
Okay. Do I have a motion to that effect?
So moved?
Do I-
I'll make a motion.
What?
I'll make,
She already made it, so you're seconding it?
sure.
Okay. We have a motion, we have a second. All those in favor? Aye. And so you'll be continued to our meeting on
March 13th.
March 13th. And then if you could just please forward to council the memorandum of, I guess it's January 9th, forward that to council and ask him if that materially affects or alters his recommendation and opinion.
And I have just the brief response.
Yeah, he'll respond and say whether his
We'll
opinion.
get a publication before.
Oh, yeah, that's why we're doing it.
Yeah. So this is where I'm coming from. So you get opinion from town council, that doesn't determine whether it's acceptable or not. It's the building inspector, right? So I don't care what town council says. If the building inspector is in a negative on this, we got a problem.
Well, you have a problem.
Well, yeah, I mean, I think we do, because I'm concerned that accessory apartments, if we're gonna call them Airbnb, I think that is going to be an issue in Wilmington, because I think the purpose of accessory apartments is not to have a turnover of people like a hotel. So we have to look at the intent. So if you're looking for something that's gonna lock it and load it in, you're not gonna find it. So we're gonna have to build on the intent of what an accessory apartment is. The second thing is,
Or at some point, it should go to town meeting.
yeah, and you're right. But as far as town council, we get an opinion from town council, that is something that should go before the building inspector and say, look, I think you need to look at this. And he has to make that determination, in my opinion only, because I would have a hard time if the building inspector said, look, I've looked at it all, with all my years of experience, I don't think this should fly. I'm gonna have hard time voting
Well, he's
for
kind of
that.
already done that, Tom. The reason we're here is because the building inspector has denied that.
But there's more information, so you give it to town council looks at this more information and says,
You want town council to go back to the building inspector to see if he changes his mind?
yeah. I mean, the
I guess
town,
you can
the town,
recommend that.
the town council isn't gonna make the decision.
Then why don't you recommend the council's decision be provided to Al and see if it radically or materially changes his opinion? Because if it does, then you're not even coming back here.
That's fine, I have no issue with that at all.
All right? So you're continued to March 13th. Yeah. All right?
Yes, no, that was just a brief response to his opinion, because I only received it on Friday.
Do we have a copy? We don't have a copy of that.
Oh, you just gave
Yeah,
it?
I just gave it some.
Okay?
Multiple copies.
Anything else?
No, that's it. I thank you very much for your time.
Thank you, folks.
Thank you
Have a
so
good
much
night.
for your
We'll
time.
see you on March 13th.
Yes, thank you.
You're welcome. Okay, next on the docket are companion cases 119 and 219. Property located at 196 Ballardvale Street, Mapvale LLC, map R2, parcel 7E. The first one is to acquire a special permit in accordance with 3.5.1.1, retail under 30,000 square feet for property located at 196 Ballardvale, and the second is to acquire a special permit in accordance with 6.6.7.7, groundwater protection district for the property located on 196 Ballardvale Street. Hi, can you please introduce yourself?
Good evening, my name is Ben Osgood, engineer with Ranger Engineering, here representing Mapvale LLC. Property is 196 Ballardvale Street, which is right in the corner of Ballardvale and Route 125. It's a 9,900 square foot retail building, and it actually came in front of the board 3 years ago, and they approved these same permits. Permits were recorded, but they only last for 2 years, so we're here re-permitting a little bit, slightly changed project. The building previously was around 12,000 square feet, so it has been made smaller. It's 9,912 square feet. The plan is to have retail and a drive-through end cap for some sort of a burger joint fast food restaurant, and then possibly a second sit-down restaurant, smaller restaurant, with the balance as retail space. It has a total of about 96 parking spaces, 50 of which are rented back to the adjacent property. The access comes in through the existing driveway that accesses 200 Ballardvale Street, which is the large office building. We have 2 points into our property that gain access. This point here being on the south side, gains access to the drive-through as well as the front parking field. The other will be mainly an exit, but you can enter into that, that entrance as well. Site is on municipal sewer, municipal water. Obviously, you know, the overhead electric, cable, and communications. The, speaking towards the need for the retail, or the, because this is requesting a special permit for retail, the use. This isn't a, you know, obviously it's in the industrial area. There's very limited services for all those people that are there. And for that side of Wilmington, there are some residences there. So part of the goal here is to provide people with, that are here in the industrial area, you know, places to eat, to shop, and so on, as well as the residents in the area. And people will be getting off the highway too, I'm sure, and it will give them some place to be able to stop as well. The other permit we're here for is the stormwater permit, because this isn't a groundwater protection zone. I'm just gonna- This is the drainage plan. It hasn't changed much from when you were here before, but the front area of the parking lot drains into some treatment swales here, grass treatment swales, into an underground treatment detention infiltration area. The rear of the property flows through catch basins and drain manholes through a vortex separator, which treats the water into that same infiltration area, which provides treatment, infiltration, detention. So we are meeting not only the Massachusetts Stormwater Management Act, but the town's requirements, which for this site are 50% more than what the Massachusetts requirements are. It is in a groundwater protection zone, so that automatically stepped it up under both the state and the town of Wilmington regulations. We're meeting the treatment. We have an 85% TSS removal rate of all water. We're infiltrating, as I said, I think 1.5 times what's required under the state and local regulations. And then we're controlling the volume and rate of flow as well. So, you know, we're protecting that groundwater. The infiltration and the treatment of that water going into the ground will be sufficient to protect that area. So I know you probably all, you may remember it, but.
Any initial questions of the applicant by the board?
What was the main purpose for the delay on that it got expired? Just,
I think, sure.
I'm just curious.
Paul Nealon, the manager of Mapville LLC. So this basically is 206 Ballardville Street 2.0. And we bought and developed 206 Ballardville Street as a speculative venture. And we didn't want to bring this online until that was fully tenanted. There was a delay in the Poncho's restaurant that put us beyond the permitting termination that we obtained 3 years ago. Didn't make sense to me to build another speculative building without having the speculative building I just built not fully tenanted. That was one reason. The second reason was we designed the building initially to have a fairly high visibility from 125 because we felt the motoring public on 125 needed to see what was in that. Well, as it turns out, the siting of the building and the costs associated with relocating the utility lines didn't make sense after the fact. So we changed the plan slightly based on the new information we had after we had submitted the application, and that's why we're here today.
Anyone else?
The original plan, if I recall it, it had it did have a drive up on the 125 side.
Yes.
The original plan. Correct. And you said the building got smaller. Is there any other, like I don't really remember the parking along Ballardvale
The
Street.
reason for that is that after the drive-through works better on the second version than it did in the first version, and the orientation of the parking is better. This is a less intense development than what's been approved prior.
We tweaked some things, the diagonal parking. That was the planning board, even after they approved it, thought it could be better. So we've tweaked that. We eliminated a wall in the back, have a slope instead, just to,
The old plan had a skewed wall along here. And after we started to do the kitchen layouts for prospective tenants, that became problematic internally. So we said, you know what, we want to have a more traditional 90-degree end wall, and we could also pick up some diagonal parking here, which we thought had a lot of value. So we sacrificed square footage for function.
And the only, I'm comfortable with the layout, and, one of the things that, whenever a project like this goes on to an existing site, I fear that what's happened on 120, on 38, where the daycare's in the back and the Sonic was out front. It's just a train wreck as far as traffic going through the site. And this one looks like you have there's almost like a dedicated traffic lane on the right, or the downward side of the downward side of the berm. The parking that is called head-on onto that traffic lane, there's no room to put any type of a berm or anything to basically.
we have. And that was a comment from the planning board, so we've added that. We've added a curb. Right,
So there's a little
there-
planted buffer or something right along there?
The
Right.
problem is we don't own that property.
Right.
Right, so you're making a request on a piece of property that I don't own. I have a very good relationship with the owner of that property. As a matter of fact, this was developed as an amenity to the offices. This is the largest property owner on Ballardvale Street. And there was a strategy that was put in place that we needed to provide goods and services to the people who work out there. And that's what was driving this development. But I don't have, we have an intention to try to work together, but I don't have the legal right to do that without their cooperation.
Right, because the property line goes right down the middle of your berm.
Correct. Right.
So
There's
the outward,
there's an easement here.
so the outwards, there's an easement,
Right,
Yeah, there's cross easements between the two properties.
right.
and it covers the berm, but not the right-of-way, or call it a right-of-way, or whatever it is. So is the easement the actual travel lane?
Yes.
It-
Yep.
Well, there's all kinds of easements.
Yeah, there's a bunch of easements, but there is a travel lane easement that comes
Yeah.
down through here.
They can cross our property, we can cross their property, there's cross easements for utilities. The actual parking on the right side is a long-term parking easement so that they can be compliant with the zoning regulations. It's pretty well
I
thought
mean, I
out.
think with without the additional berm, I think there is a traffic lane there, which
Yeah, the queuing here is very
much
good.
better. I think it would be better if the berm were put in, but I
Well,
think
we will make best efforts to do that. Make sure we understand we're talking about right here, right?
Right here.
where that head-on parking is right into the traffic.
So the planning board had made that comment, and I don't know if it's a condition under the planning board, I can't remember, but it's,
Yeah, speaking of that, do we have any recommendations on this case?
They have not approved this plan yet. I don't know if they've written a recommendation, but,
We'll find out.
so we have worked out everything. The plans have all been revised to address everything. And there is a sewer study that they wanted done. And they wanted us to use the,
Are you aware of any recommendation from planning on this? You say that they haven't approved the plan, but do you know if they've issued a recommendation one way or another? Because we don't seem to have one.
I don't think there's a written recommendation. There is a, from everybody, that the town engineer has said, yep, you're okay.
I mean,
Planner has said that, but nothing from the board.
it's a subdued plan from what was approved before.
Right.
So, but just for purposes of knowing. That would be nice.
Can I just ask one more question? Since the permit was originally issued, I don't know, 3 years ago, or however long it was, has anything changed as it relates to the groundwater or the requirements for what you have to recharge, or has anything changed that would change the system that you had
No.
previously designed?
No, the regulations were complying with the current regulations, which were the same regulations in
Okay.
place at that time.
That's fine.
Anything else?
So we typically approve cases like this when the planning board gives a recommendation. If the recommendation is negative, we've still approved in the past, but we usually ask for a recommendation from the planning board. So why wouldn't you have gotten that first before you came here?
We expected to have it by now. We continued the first meeting waiting for that.
Yeah.
They came up with this second, this requirement to do the source study.
Yeah.
We're doing that now. We've worked every detail out, and they're going to approve it, I believe, at the next meeting. What I know the board doesn't have a decision written up, and what I would ask is that if we, just to keep, I know you don't usually approve them before they issue their approval, but if the board could be possibly ready, if they so choose to issue an approval and be ready to issue it at the next meeting.
Well, let's open it up to the public, and then we'll kick it back, and then we'll make a determination of how we're gonna handle it tonight. Is there anybody here who wishes to be heard on this particular application? Sir? If you could just state your name and your address, please.
Jeff Wood, 18 Frederick Drive. I just really have a point about, you said you went to the planning board, and have they approved your open swale plan?
The engineer has approved it. The engineer has said it's good. Like I said, they haven't voted to issue an approval, but the engineer has said that it's acceptable.
So I've been to many planning board meetings. I've heard them say repeatedly, and taken other developers, rake them over the coals around open swales. They don't approve them. So I'd say, as a board, I would not go forward until you have the planning board approval. That's it.
Thank you, sir. Anyone else wish to be heard? Going once, going twice. Public hearing is closed. I will bring it back to the board for any additional questions, comments, or motion.
I guess the question I have then is that this open swale thing,
So it's an open, water flows into it's a grass swale.
but is that different than the original plan?
No.
Oh,
It's not any different than was approved before.
it was approved 3 years ago.
Extensive discussions with Paul Looney about, the guy is very particular in his designs. And so, reason we're before you to answer your question is, we're waiting for a sewer study for a project that was already been approved that has less sewer demand than was approved. So I know that we need to get it, and I understand the procedure and the sequence, but the likelihood that the sewer is not suitable is nil.
So yeah?
Yeah,
Right. So what you're basically saying is that us jumping before the planning board and let's say giving you approval, how does that benefit you?
It doesn't necessarily, this is more of an information, to bring you up to speed. I want to get this thing started in the
Well, you
spring.
wouldn't get it, you get it done in the spring. Right now, there's snow on the ground, it's just a little
Yeah,
cold, right?
but-
So as far as protocol, my recommendation would be to get their, not their approval, but get their recommendation first, because that's what we've done in the past. And again, I think these guys have been around longer than I have, and even though some get rejected, we've approved them. But here's a protocol we use. And in my opinion, if we use the protocol for one, we have to do it for everybody. So by allowing you to do this, someone may come and say, well, you did it a month ago, you didn't need them, so why aren't you doing it for us? So that's just my...
Oh, I would say, the only thing I would say to that, and it's a fair comment, the only thing I would say is that this has already been approved.
Well, not this particular one.
But it's less burdensome than the one that was approved.
But, I don't know...
So I'm just saying there's a
No,
difference.
I get it, but I don't know if any laws or environmental laws have changed over the last 3 years. I don't know about the sewer. system that they're talking about? Is that the result of something that's changed over the last 2 or 3 years? You know, I just don't have the answers for that.
Is the change substantial enough, just, not to just request an extension? I mean, why is it not an extension?
It already expired.
It
It
without
actually
the-
expired.
without the
Yeah,
request.
we probably could have done this with a minor change administratively with the planning department, but the laws or the rules don't allow you to extend beyond a 3-year period. You have to have substantial construction in place before the 3-year period ends, and we weren't able to do that.
All right, so what's the, oh, Ray, you want to speak to
I
it?
mean, I can see where Tom's coming from, and I think this board has to set priorities. And I think the priorities are, if one of the agreements are that a finished plan has to come in from planning board and approved, even if it's that plan over here or that plan, if that's the one we're looking at, that's the one that we should be waiting for planning board to say it's approved, it comes to us. It
Well, you
seems
mean a
like-
recommendation? Sometimes we vote
Recommendation,
against what the
approval, yes.
planning board recommends.
Only because, just say if the smallest thing becomes a fraction could come into the next stage of, mathematics, and the problem is, becomes a problem. So the headed off is, I think, if we stay on track, that if a homeowner comes in or a big business comes in, it's the same standard. Right now, we're waiting for planning board, recommendations. We have no recommendations. We have the engineer saying it's okay, but other meetings, I've seen a piece of paper saying it's okay. I haven't seen it.
Well, let's just ask. I mean, do you guys have any heartburn? You have 2 members here who want to get a recommendation.
This is not an issue. If you want to kick the can down the road, that's fine with
Okay.
us.
I mean, if the applicant doesn't care, and you have 2 members who do, then I mean, why don't we, the motion is fairly clear. Somebody wants to make it.
I'll make a motion to continue case 1-19. We're going to take them separately or at the same time.
We can bundle them together.
And 2-19 to the March 13th hearing in the hopes that we have a planning board recommendation before that
To
meeting.
get whatever town recommendations they're having to do with this project, if we could have them prior to the 13th.
So I'll second it for discussion. So do you think you'll have it by then?
Yes,
By the 13th?
by the 13th, we'll have it.
Assuming that the third-party reports come in a timely way. The problem is that we're obligated to use the vendors that are dictated by the town, which we don't have any control over the price or the delivery of. Not exactly a great circumstance for an applicant, but that's the way it is. So we can only control what we can control.
I just want,
But I
I'm
can-
thinking, give yourself as much time
Yeah.
as you need. If you feel that the 13th,
We'll work, if we need more time, then
okay,
we'll
I'll
work.
second that.
I mean, the project looks, decent. I wasn't in on the last one, I don't believe, but, I mean, that drawing, I looked it over, I have no problem with it. It's just, I'm trying to set a standard, just like Tom was saying, we need to get on board as a unit and keep it going as a unit. So, it's, no unfairness to you people, I don't wanna get you wrong, but, that's just the way, I like to see things starting.
All right, so we have a motion, it's been seconded to continue this matter to 3/13/19. These 2 matters for supplementation of the record with the recommendations from the appropriate town boards. All those in favor?
Aye.
Aye, unanimous. See you then, folks. Good luck. All right, and the last case on the docket is case 319, 911 to 917 Main Street, MT Pockets Realty Trust, map 45, parcel 137, to acquire a special permit in accordance with 6.6.7.7 Groundwater Protection District for the property located at 911 to 917 Main Street. And gentlemen, before we start, a member has indicated to me, since he is an abutter, he is going to have to recuse himself from the hearing of this matter, Mr. Lepore. That's in fact, right?
Yeah.
Okay, so we'll just give him a couple minutes. I don't know if you knew that, but I guess he's a direct abutter, so, and has not gone through whatever process he would need to avail himself of hearing it. So if we could just mark that for the minutes, that Mr. Lepore has recused himself from the hearing and has left the room. All right, good evening, gentlemen, if you can introduce
evening.
yourself.
My name is Michael Newhouse. I'm counsel for the applicant. This is Bob Attenzio, who's the trustee of the trust that owns the property, and that is the applicant in the matter before the board. Just quickly to give a background to the site and to what brings us before the board. Back in the early 2000s, beginning in 2003, Mr. Artenzio began the permitting process to develop the property that's known as 911 through 917 Main Street. It's located on the westerly side of Route 38 Main Street, near the Woburn line. It abuts the Maple Meadow landfill to one side and some other privately owned property on a couple of other boundaries. Mr. Artenzio successfully permitted the property through the early part of the 2000s. He went through a rigorous regulatory process, which included, but is not limited to, site plan review, stormwater management, a special permit from this board relative to the groundwater protection district, and he filed a notice of intent and received an order of conditions from the Conservation Commission. And that was all done back in the early to mid 2000s. In 2013, Mr. Artenzio obtained a certificate of compliance after he completed the second phase of his development, and his regulatory process was done. He's occupied the building in the rear for several years now, and he did so, with the benefit of numerous permits and approvals that I just outlined. However, since 2013, since receiving the certificate of compliance for the order of conditions, he did some minor work on the site, which he should have gone in to get an order of conditions for, and neglected to do that. So after the fact, he did in fact file a notice of intent with the Conservation Commission. A couple months ago, 2-3 months ago, the Conservation Commission issued the order of conditions based on positive recommendations from all applicable departments, including the town engineer. And everything complies with not only the Wetlands Protection Act, but with the policies of the Conservation Commission. In addition, even though there are no new buildings, there's no new parking areas, there's no alteration of the building, there's no reconfiguration of parking spaces, there is an area that originally was planned to be gravelled, which is now paved. So the planning board took, I guess, a cautious view of it, and asked Mr. Artenzio, or directed him to go through the site plan review process, notwithstanding whatever legal position we might have had. Mr. Artenzio agreed. We went through the site plan review process. The hearing was closed and the site plan review was approved. Simultaneously, we went through the application for a stormwater management permit. Stormwater management permit was approved. All policies and regulations complied with without any waivers of any kind. So the final step in kind of this do-over for the regulatory process is here before you, asking for a special permit for the Groundwater Protection District in accordance with the applicable bylaw provisions. There are fairly detailed plans before you, which we thought it prudent to give detailed plans to the board. Just to summarize what's going on in this, again, no new parking areas, no additional parking, et cetera. The building is exactly the same as when it was previously approved by this board several years back. They are removing some existing paving, removing some existing gravel and planting grass, and then they're increasing the size of detention pond area, and that's it. Everything else is the same as it was when the board previously approved the special permit.
Counsel, let me ask you, have you seen the planning board recommendation of February 6th?
I have not.
All right, I'll just read that, just because it's asking for information that you may have.
Okay.
It says, at its meeting on Tuesday, February 5th, the planning board voted to recommend as follows. To recommend the Board of Appeals have the applicant provide the proposed impervious area calculation. The planning board issued approvals for site plan review and a stormwater management permit in December, and recommends approval once the impervious area calculation is provided. The decisions for each approval are attached for reference. So they're just asking that a proposed impervious area calculation be provided to the board. Do you have that?
I believe I do, but what I'd rather do, Mr. Chair, if it's acceptable to the board, we're not in some of the, under the same time constraints as a new development might be. Rather than pull out what I believe is a correct answer, I'd rather circle back with the engineer and make sure I have that and have it accurate. So, Bob, I assume that makes sense to you as well. We'll go ahead and
I mean,
continue
it's
to provide
pertinent,
that.
and if the board's looking for it, based upon the previous discussion, at least with one member present, we probably would like to have that before a decision is made, so.
Yeah, I'm now, I thought that information had been provided, but again, I'd rather circle back with the engineer and make sure.
When do you think you can have that next meeting, or?
Certainly, if you continue to the next meeting, which I assume is in the regular
Everybody-
scheduled meeting in
Everybody else, we're
March.
taking the agenda tonight and putting it on for March 13th.
March 13th. I would fully expect we can provide that figure and the backup within a matter of days, as long as the engineer is not taking off on vacation next week, and March 13th would be great.
Well, do we have, well, first of all, before I do that, let's see if there's anybody here that wishes to be heard on this particular application from the audience. No, going once, going twice, the public hearing, I'm not gonna close the public hearing only because we have some additional information, so I'll leave the public hearing open, but I suspect that once you provide that, I'll close it at the next meeting.
Very good.
Do we have a motion to continue this matter?
So I'll make a motion to continue case 13-19 to require a special permit in accordance with 6.6.7.7 groundwater protection district.
Okay, we have a motion to continue to the next meeting. We have a second. All those in favor?
Aye.
Aye, unanimous. See you on March 13th, gentlemen.
Okay, thank you.
Thank you.
Thank you. That concludes the regular docket and agenda of the meeting. Do we have any administrative matters that need to be taken care of?
Just have the minutes from last month's meeting to be approved.
Okay. I believe everyone's seen those.
When we get,
Oh, yeah, why don't you go get Ray in here? Was he here? Present at this meeting were myself, Mr. Barletta, Tom, Jackie, and Ray, so. All right, Ray, the last piece of business we have is we're voting on approval of the minutes of January 16th, 2019. All members are present. I believe the minutes have been circulated. Do you want to take a peek at them? Do we have a motion?
Make a motion to approve the meeting minutes of
January 16th.
January 16th.
2019. We have a motion to approve the minutes. Do we have a second?
Second.
We have a second from Mr. Syracuse. Are all those in favor? Aye. Aye, the minutes are approved. Any more business that needs to be taken care of tonight?
No,
All right, that concludes the meeting. Thank you, folks. There's no public comment. There's no public comment at the Board of Appeals meetings, but thank you.